So this is our third video of the series. In this we'll talk about the probate without a will. When a person dies without telling those ones he leaves behind what he wants, essentially on a form of a will, it is said that he died intestate. An intestate estate is also known one where the will is presented to the court and is invalid. Sometimes they can be forged. The probate process for an intestate estate includes distributing the deceased assets according to the law. If a deceased person has no assets, then we don't have to go through this probate. In general, a probate court proceeding usually begins with the appointment of an administrator to oversee the estate. The administrator functions as the executor, receiving all of the legal claims against the estate and paying off the outstanding debt, all of the bills that have accumulated. The administrator is tasked with locating any legal heirs of the deceased, including any surviving spouses, children, and or parents. The probate court will assess what assets need to be distributed among the legal heirs and how to distribute them. The probate law is in most estates divides property among the surviving spouses and children of the deceased first. Assets transferred to the government is known as an enchantment. Estates do typically have a time frame for the claim of any assets by the heir who may step forward. A spouse as a joint property owners. Community property laws can recognize both spouses as joint property owners of an estate. In-state proceedings, in effect, the distribution hierarchy typically starts with the surviving spouse, if unmarried or widow, at the time of death. Assets are usually divided among the surviving children. After a spouse and the children are considered, other relatives may come in. Distribution may deem appropriate for them. Close friends of the deceased don't normally come into the equation unless the beneficiary had a bank account, joint account with this person, in which this account had the right of ownership, or if owned property with this other person. The joint asset will automatically be owned by the survivor partner. If an individual has no will and no assets, then any remaining assets go back to the state. If you have any questions, please reach out. I know that this process can be lengthy. It can also cause a lot of emotional trauma as we deal with not only missing out on having our lovely friend with us, our departed partner, or a parent. Those could also be different cases for that. But just please reach out. We have all of the resources that you need. Again, we'd love to give you a copy of the book. It gives you a guide as to what are the documents that you need to collect, regardless of whether you find yourself in a probate or not, since you have to collect all of the assets, and this is a guide that will help you do that. You don't have to go through this process alone. In fact, you are not able to go through this process alone. So reach out to get proper counsel. Hope you have a great day.